Should you testify in your domestic assault trial? Well, that's a very loaded question. So first of all, in Canada, we have the right to remain silent, so you do not have to testify. But in the typical domestic assault trial, it's typically, not always, but your word against the complainant. Like whether you're a man charged with domestic assault or whether you're a woman, it's going to be your word against your boyfriend or husband, or as the case may be, or girlfriend or wife. Now, what happens? So the complainant, the victim, takes the witness stand and they're examined in chief by the Crown prosecutor, then they're cross-examined by myself, for example. Now, I have prepared my client, like we have gone through this for hours through mock examination chief in our office, mock cross-examination, so that I'm very confident that they're going to do well in the witness stand and come across. Because it is, you know, whether you're telling the truth or whether you're lying in a courtroom or in between, you know, that has nothing to do with the way you come across. I mean, the most truthful witness in the world could come across so brutally that they sound like a liar because some people are nervous, they're not prepared. And it's the same with accused, it's the same with complainants. I've seen complainants who are probably telling the truth who come across terribly. I've also seen lying complainants come across fantastically. A sociopath's able to lie, men, women, very easily and very capably. But with proper preparation, that's the key to winning these cases, to get your client properly prepared. So at the end of the victim's testimony, you in your mind as defense counsel, I'm going to say to myself, well, how did I do? How is her credibility and reliability right now in the judge's mind? Have I raised a reasonable doubt? Now, if the answer to that is a compelling, and I say compelling yes, my practice might be to say to the client, look, I think we can get away without you testifying. I think we've made significant inroads. It's so obvious. But it's risky. It has to get to that point for me. If I have any doubt in my mind, because I may disagree with the judge, I may say, I try to be objective. I try to look at the case from above as a judge. I have finished. How did I do? Okay, what is the status of this case in the judge's mind right now? Do I need to call my client? Now, bear in mind, I know that he or she is properly prepared. I know they're going to do a good job because I have grilled them for literally 10 hours. I have 3 sessions with my clients on this. So it would only be for me, every case is different, but it'd only be for me in a case that I'm so convinced of the reasonable doubt at the end of the cross-examination that I might not call the client. That's a hard case. It's a gray area, right? It's a difficult decision. But so in other words, usually in domestic assault cases, most of the cases I've done, I've called the client to good effect. I'm usually happy with that decision because they do a good job, especially in a case where we've already got reasonable doubt. It only adds more. It's been rare, from my experience, to have a client not testify well on the witness stand in the cases I've done, just through effort. It takes effort and hours. But it's the client's decision ultimately, like some clients, you know, and I have come across, I must say, I've come across the odd client in my career who's just not a person who's able to speak in public. If you can't speak in public, you're screwed in a courtroom. You may be the most truthful person in the world. You're not going to come across well. You're going to be destroyed by a good lawyer. And that happens to complainants all the time who are telling the truth. It happens to accused. Some accused are innocent, by the way. I know people don't like defense counsel necessarily, but there are innocent accused. And there are innocent accused who are not good speakers, and they're not going to come across well, and it's hard to prepare those people. But you know, you do the best you can in that situation. So it's a loaded question. Should I testify? Really, every case is different. The bottom line in a domestic assault is this: you should usually testify unless the reasonable doubt is so compelling that you know the judge is going to acquit. And it's a risky decision even then because you may misread it. The safe bet with a properly prepared client, the very safe bet, because you know they're going to do well if they're properly prepared, is to call them as a witness and let the chips fall. So that's it in a nutshell. Should I testify in a domestic assault case? Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.